Okay, a very good evening and a very happy new year. The exam is in 3 days now, and I hope the preparation is going well. Although there is only one student who's watching me right now, I hope all the other people will join eventually, but I have to start the quiz on time, so I'm starting it. Let's begin the quiz. Today we are going to deal with Constitution of India, Negotiable Instruments Act, Juvenile Justice, which only has juvenile justice has 3 marks of weightage in the exam, the prelims exam of Madhya Pradesh. Negotiable Instruments Act has only 4 marks weightage, and the Constitution of India has 5 marks of weightage now after the three acts being added in the prelim syllabus. Okay, now can you guys quickly reply with a hi in the comment box so that I know you are active and ready to answer the questions? Please comment a hi in the chat box so that I know that you guys are ready to answer the questions. And let's quickly begin with the first question. Any person aggrieved by the order made by the competent authority under the Juvenile Justice Care and Protection of Children Act 2000 can appeal to the Sessions Court, the High Court, Home Minister, or the Chief Judicial Magistrate. Okay, so the time is over, and the answer is option number one, and it is mentioned in the section 23 that the person can appeal to Sessions Court. Okay, let's move ahead then. Who, as per Section 2, Clause 1 of the Juvenile Justice Care and Protection Act 2000, is a juvenile in conflict with law? A juvenile who is alleged to have committed an offense and has not completed 18 years of age as on the date of commission of such offense, or 12 years of age as on the date of commission of such offense, 16 years of age, or 14 years of age. As per Section 2, Clause 1, who is a juvenile in conflict with law? And the answer is option number one. Who has not completed 18 years of age is a person juvenile in conflict with law. Okay. Which one of the following is not correct? Okay. Yes. So, according to Yash, it is option number two. Which of the following statements is not correct? Now we have four people with us. Please reply with a hi or a comment that you guys are ready to answer the questions, and then I'll move ahead. We are at question number three. So, according to Yash, it is option number two. Which one of the following statements is not correct? One or more juvenile justice boards shall be constituted by the state government for every district. Each juvenile justice board shall consist of a metropolitan magistrate or a judicial magistrate and two social workers, of whom at least one shall be a woman. The order passed by the Juvenile Justice Board in absence of any member at any stage of proceeding shall be invalid. Power of the Juvenile Justice Board may also be exercised by the High Court and the Court of Session when the proceedings come before them in appeal, revision, or otherwise. You have to mark the statement which is not correct. Let's see the answer. And the answer is not two, but option number three. The provisions are contained from option number 4 to 6. Obviously, the order passed by the Juvenile Justice Board in absence of any member at any stage of the proceeding shall not be invalid, but it has to be a valid order. Under Section 202, Clause 12 of the Juvenile Justice Care and Protection of Children Act 2015, child means a person who has not completed 21 years of age, 18 years of age, 14 years of age, or 16 years of age. If you were asking Sagar the previous question, it is not option number 4, but it was option number 3. Okay, according to Sagar, it is option number 2. Let's see the answer. It is option number 2. According to section 2, clause 12, it is 18 years of age and not 16 years of age. Yes. Who shall review the pendency of cases of Juvenile Justice Board on quarterly basis? Chief Judicial Magistrate, high level committee consisting of the executive chairperson of the State Legal Services Authority, district magistrate, or chairperson of Human Rights Commission. Who shall review the pendency of cases on quarterly basis? And the answer is option number 1. The person who will review the pendency of cases in the Juvenile Justice Board will be the Chief Judicial Magistrate, that is the CJM. Which of the following orders may not be passed by the Juvenile Justice Board after conducting inquiry of a child in conflict with law? Direct the child to attend the school, direct the child to attend a vocational training center, sentence the child to imprisonment till he attains 18 years of age, direct the child to perform community service. Not be passed. And the answer is option number 3. That is obvious. We have 3 people, but nobody is answering. Only Yash is answering yes. Sagar has also answered yes. The correct answer is option number 3. Sentence the child to imprisonment till he attains 18 years of age. They cannot do it. The juvenile justice, the member of the Juvenile Justice Board, where after the inquiry under section 15 of the Juvenile Justice Care and Protection of Children Act 2015, the Juvenile Justice Board is satisfied that a child below 16 years of age has committed a heinous offense and should be tried as an adult. It may commit the case of the sessions court concerned for trial of the child as an adult, try the child as per the procedure provided in CRPC, return the charge sheet to the investigating officer for presentation in the court concerned, transfer the case to the children's court for trial of the child as an adult. Come on, guys. Section 15, I think this is one of the most important provisions of Juvenile Justice Care and Protection of Children Act 2015. Okay, Sagar has answered. Yes, it is option number 4. Um, the board can do one thing, and which is it transfer the cases to children court for the trial of child as an adult. Okay, let's move ahead with the next question. A children court trying a child in conflict with law for a heinous offense is not empowered to hold trial of a child as an adult, hold inquiry of the child as a juvenile justice board, sentence the child to imprisonment for a term of 10 years, sentence the child to a place of safety till he attains the age of 21 years. Not empowered to. Please remember in MP, always remember to see not, does not. Yes, it is option number 3, which is correct. Uh, they cannot, the child children court cannot sentence the child to imprisonment for a term of 10 years. Otherwise, they have all the powers. Uh, Let's move ahead with the next question. Where, after the inquiry under Section 15 of the Juvenile Justice Care and Protection of Children Act 2015, the Juvenile Justice Board is satisfied that a child above 16 years of age has committed a heinous offense and should be tried as an adult. Okay, this is a repeated question. In which of the following situations the general principle of presumption of innocence of a child in conflict with law shall not be applicable when the child is charged for the offense of murder punishable under section 302 of IPC, when the child is charged for an offense of gang rape punishable under section 376 2G of IPC, when the Juvenile Justice Board has passed an order under section 15 read with 18 clause 3 of Juvenile Justice Care and Protection Act 2015 that the child should be tried as an adult. None of the above shall not be applicable. General principle of presumption. It is very easy, guys. Oh, hi, welcome, Shaktija. All the best for the MP exam. The answer is option number 4. Yes, none of the above. The general principle of innocence shall be applicable in all the cases when the child is the general principle of presuming when the child is below the prescribed age, the presumption of innocence, whether it is a gang rape or any offense, the presumption of innocence has to be taken in account for every offenses. So this was a tricky question. Yes, Sagar was only one to answer it correctly. When a child in conflict with law is in custody while undergoing trial is declared under 18 plus 3 of Juvenile Justice Care and Protection Act of Children Act upon crossing the age of 18 years during the course of trial, which of the following option is available to the trial court in such a situation? To allow the child to go home after advice or admonition, to drop the proceedings and release the child from custody forthwith, to direct the child to be released or probation of good conduct, send the child to a place of safety. Anybody? Nobody? Okay, this is option number 4. Send the child to a place of safety. This is the only option available to the trial court in such a situation where the child is undergoing trial and where he's declared that upon crossing 18 years of age, he'll be crossing 18 years of age during the course of trial. The court can send the person to the place of custody. Which of the following cannot be a ground to deny bail to a person who is apparently a child in conflict with law? Not be a ground. Where the offense alleged against such person is a heinous offense and the child has been ordered to be tried as an adult under section 18 clause 3 of Juvenile Justice Care and Protection of Children Act, where there are reasonable grounds to believe that the child may come into the association with a known criminal if released on bail, that a person may be exposed to moral, physical, and psychological danger, that the person released on bail would defeat the ends of justice. Let's see the answer. Anybody? We have 5 people now. The answer is option number 1. That is, when the offense alleged against such a person is a heinous offense and the child has been ordered to be tried as an adult. Yes, Sagar is correct. Sagar is correct. So, in such a situation, there's no ground to deny the bail. Under the Juvenile Justice Care and Protection Act 2015, who may not be designated as a child welfare officer? Head constable, assistant sub inspector, or all of the above? Not be considered. Not be considered. The answer is constable should not be designated as a child welfare officer. Otherwise, assistant sub inspector or a sub inspector can be designated as a child welfare officer. Not be. Not be. Where the offense under the Juvenile Justice Care and Protection of Children 2015 Act 2015 is punishable with imprisonment for less than 3 years, then such offenses shall be cognizable, bailable, and triable by the magistrate of first class, cognizable, non-bailable, and triable by the magistrate of first class, cognizable, bailable, triable by the magistrate, non-cognizable, non-bailable, and triable by the magistrate, by any magistrate, for less than 3 years. Okay. It is option number 3, cognizable, bailable, and triable by any magistrate. Yes, Yash is correct. How many fundamental principles are provided in Section 3 of the Juvenile Justice Care and Protection Act 2015? 12, 14, 16, or 18? Fundamental principles. Yash is saying 1, and the answer is 16. It is option number 3. Which statement with reference to section 101 of the Juvenile Justice Care and Protection of Children Act is wrong? An appeal shall lie against an order of the board before the children's court. A second appeal shall lie from any order of the Court of Session passed in appeal under Section 101 before the High Court. Any appeal aggrieved by an order of the Children's Court may file an appeal before the High Court. Any person aggrieved. No appeal shall lie from any order made by a committee in respect of finding that a person is not a child in need of care and protection. Yes, it is 16. Correct, Shaktija. Is wrong. This is very obvious. Yash is saying option number 3. Let's see which is the correct answer. The correct answer is not 3 but 2. 2 is wrong. A second appeal shall lie from any order of the Court of Session passed in appeal under section 101, not before the High Court. Who constitutes the child welfare committees for exercising the powers and to discharge the duties conferred on such committees in relation to child in need of care and protection under JJ Act? Central government, state government, juvenile justice board, none of the above. Who constitutes the welfare committee? Okay, is it state government? Let's see. Yes, it is state government according to section 27 clause 1. How many total members are there in child welfare committee constituted under JJ Act 2015? 5, 4, 8 or 6? According to Sagar it is 8. Let's see the answer. I think Shaktija is counting. The correct answer is not 3 but it is option number A, which is 5. There are 5 members in the um, committee, child welfare committee, not 6. In which of the following case it was held by the Supreme Court that Juvenile Justice Board should not be silent spectators? Naresh versus State of Maharashtra, Mukesh and others versus State of NCT Delhi, re-exploitation of children in orphanages in State of Tamil Nadu versus Union of India and others, none of the above. This is a landmark case. Let's see the answer. Yash is saying option number 3. And it is option number 3. It cannot be Mukesh and another versus State of NCT Delhi because they themselves did not send the like they themselves sent the person to juvenile justice, and it is exploitation of children in orphanages in the state of Tamil Nadu versus the Union of India and others. In case of heinous crime, preliminary assessment has to be disposed within how much time? 4 weeks, 4 months, 3 months, 6 months. Come on, guys. It is 3 months. The preliminary assessment has to be disposed within a period of 3 months. Let's move ahead with the next question. Selection for registered institution for placement of each child requiring institutional support based on the child's age, gender, needs of the child, all of the above. Come on. Anybody? Let's see the answer then. The answer is option number D, which is all of the above. The considerations will be given for all the. Yes, Sagar is correct. The answer is D. Which section under JJ Act 2015 provides the power to Child Welfare Committee that the committee shall have the authority to dispose of cases for the care, protection, treatment, development, and rehabilitation of children in need of care and protection, as well as to provide for their basic needs and protection? 29 clause 1, 29 clause 2, both of the above, none of the above. Come on. Section based question. It is section 29 cross 1, which is option number 1. Okay, which section under JJ Act 2015 provides the process of rehabilitation and social reintegration? 38, 39, 42 or 45? Again, a section based question. MP में ऐसे questions आ सकते हैं. I've picked only the important sections. Nobody? Let's see. It is section 39, which provides the process of rehabilitation and social integration of child with the normal society. Yes, it is of section 39. Okay, so JJ Act is over. Let's see how's the Josh, guys. You guys are very quiet today. What happened? Please start commenting in the chat box. Are you able to answer the questions? And then let's move ahead with the Negotiable Instrument Act section, and then we'll move with the Constitution of India. Okay. A negotiable instrument which is delivered conditionally or as a collateral security or only for safe custody and not for the purpose of absolute transferring the property therein is called custody bill, escrow, bill in set, security bills. Yes, the three acts JJIT and POXO. The video is blurred. Is it blurred for anybody else also? Because it is not 144p, Yash. I have increased the quality. I've checked the settings. Tabhi. It is 480p, not 144p. Okay. Let's see the answer. It is visible properly, ma'am. Okay, okay. So let's see the answer then. It is escrow, which is a kind of negotiable instrument act and which is delivered conditionally or as a collateral security. Okay, okay. Let's move ahead. When the check is not physically transferred to the drawee bank for the purpose of clearing, such check is called electronic check, duplicate check, truncated check, none of the above. Come on. It is a truncated check. So when the check is not physically transferred for the purpose of clearing, but it is transferred non physically, then it is a truncated check. Yes, correct, Yaksh. Payment through a negotiable instrument act is valid till a specific period until its maturity. Such period or course is known as validity of a negotiable instrument, payment in due course, holden in due course, either one or two. Let's wait for 5 seconds and then let's see the answer. It is both 1 and 2. Validity of a negotiable instrument and payment in due course. Yes. In case there are several drawees of a bill of exchange who are not partners, each of them can accept the bill of exchange for himself only. Each of them can accept the bill of exchange for himself as well as others. Only if authorized can one accept the bill of exchange for the other. None of the above. If there are several drawees of a bill of exchange and they are not partners. It is option number 3 and it is mentioned under section 34. They can only accept if they are authorized and to accept the bill of exchange for one another because they were not partners. Let's move ahead with the next question. A is the bill, or A is the holder of the bill of exchange made payable to the order of B. which contains the following endorsements in the bank. First endorsement B, second endorsement Ram Singh, third endorsement Raichand Thakur, fourth endorsement Peter D'Souza. With regard to the bill, A put in a suit against Peter D'Souza and strikes out without the latter's consent. The endorsement Ram Singh and Raichand Thakur. A is fully entitled to recover the amount from Peter D'Souza. A is not entitled to recover the amount of the bill of exchange from Peter D'Souza. A is entitled if Peter D'Souza gives his consent. None of the above. Let's see the answer. This was a trickier question, and it is option number two, which is the correct answer. A is not entitled to recover the amount of bill of exchange from Peter D'Souza. He is not entitled to do that. An acceptor is bound even when the endorsement is forged when he is, yes, Shaktija is correct. He is aware that such an endorsement is forged. He is unaware of such an endorsement being forged. He is not bound under any circumstance. He is bound irrespective of whether the instrument is forged or not. Let's see. It is option number one. He's aware, he's bound even when the endorsement is forged, when he's aware that such an endorsement, he had a notice of it. When the negotiable instrument is sent by the payee to the drawer or the payer for the purpose of payment or acceptance, it is called demand, encashing, withdrawal, or presentment. This is very basic. It is called presentment. Okay? Okay. In case of a dishonor of a bill of exchange, the drawer can go to the notary public in the court to file a complaint. Such a request to note the fact of non acceptance is known as protest, noting, petition, or complaint. Shaktija has immediately answered the question with option number one, and it is not option number one, it is option number two. And a promissory note or a bill of exchange has been dishonored by non acceptance or non payment. The holder may file a complaint to the notary, and in case of a check, it is protest, which is under section 100. Noting under section 99 must include date of dishonor, reason if assigned for such dishonor. If instrument has not been expressly dishonored, the reason why the holder treats it as dishonored, all of the above. Noting. Okay, okay, yes, Shaktija, so Shaktija answered it correctly. Yes, it must contain all the ingredients mentioned. When a promissory note not has been dishonored by note has been dishonored by non-acceptance, the holder may, with a reasonable time, cause such dishonor bid to be noted and certified by a notary public. Such certificate is called presentment, notice of protest, protest of noting. The certificate. Let's see the answer. It is protest. So the certificate granted is a protest, but the complaint made is noting. Delivery of an instrument can be actual or constructive, or none of the above. It can be either actual or it can be constructive, which is under section 46. The endorsement of negotiable instrument followed by delivery transfers to the endorsee the property in the bill, provided the endorsement must be endorsement in full, does not transfer the property in the bill to anyone, transfers to the endorsee the property in the bill, transfer to the holder the property in the bill. Let's see the answer. Yes, it is option number three. Delivery To be effectual must be made by the party, and it actually transfers the property to the endorsee in the bill. When in presentment for payment to be made under section 65 of the act, when it has to be made, presentment for payment can be made at any reasonable time. Presentment for payment must be made during the usual hours of business, and if at the bank, then within banking hours. There is no such stipulation on the time for presentment. None of the above. Come on. It is option number two, during the usual hours of business, and if it is a bank, then within the banking hours. Okay. Can a holder of a negotiable instrument endorsed in blank convert the endorsement into an endorsement in full? No, such a conversion is not possible under the Act. Yes, the holder can, without signing his own name and by writing above the endorser's signature and a direction to pay to any other person as endorsee, convert the endorsement in bank into an endorsement in full. Yes, the holder can, by signing his own name and by writing above the endorser's signature, a direction to pay to any other person as endorsee, convert the endorsement in blank to an endorsement in full. In which situation an endorsement in blank can be converted into an endorsement in full? Let's see the answer. It is on option number two, and it is mentioned under section 49 that they can do it without signing his own name and writing above the endorser's signature a direction to pay to any other person as endorsee, convert the endorsement in blank to the endorsement in full. Okay. Under Section 76, Clause B of the Negotiable Instrument Act, the engagement to pay must have been entered into at maturity, after maturity, prior to maturity, none of the above. Let's see the answer. It is option number three, and which is prior to the maturity. Okay. A note under Section 99 of the Negotiable Instrument Act should contain, amongst other things, place of the notary, charges of the notary, both 1 and 2, none of the above. Come on. This is very simple. And the correct answer is option number two. It should only contain the notary's charges. Why would they even need the notary's place? When a bill is drawn, accepted, or endorsed without any consideration, it is called escrow. Accommodation bill, clean bill, none of the above. Let's see the answer. It is option number two. It is known as an accommodation bill, which is Hi Bohemia. What Hindi? Can you please explain? Should I speak in Hindi? हिंदी में बात करूं? तो अकोमोडेशन बिल है ऐसा बिल जो अगर विदाउट एनी कंसिडरेशन इफ इट हैज बीन एक्सेप्टेड और endorsed, तो it is called accommodation bill. A notice of protest under Section 102 of the Negotiable Instrument Act 1881 may be given by the notary public who makes the protest, must always be given by the notary public who makes the protest, must be given by the holder, none of the above. Let's see the answer. The answer is answer है option number one. Option number one correct answer है may be given to by the notary public who makes the protest, and the notice should be given by the notary public. Notary public ही notice देता है. Dishonor of a negotiable instrument by non-acceptance is covered under section 90, 91, 92 or 93. Let's see the answer. And the answer is option number 2, which is 91, section number 91, whereby dishonor of a negotiable instrument by non acceptance is mentioned. Okay, where the drawee is incompetent to contract or the acceptance is qualified, the bill may be treated as dishonored. Dishonor of a negotiable instrument act for non-payment is covered under 92, 82, 72, or 91. Let's see the answer then. The correct answer is option number 92. Correct answer option number 92 है बोहेमिया. I'm speaking in हिंदी में बात कर रही हूँ. Option number 2 is the correct answer. Option number 1 is the option number 1 correct answer है. 92 में for non payment है. 91 में for non acceptance है. The Negotiable Instrument Act Instrument Act 1881 came into force on 18th December 1881, 21st December 1881, 1st March 1882, or first. Okay, the option 4 and 3 are same. Please answer the question. This is very basic. The date of commencement. Yes, correct answer is option number 3, which is 1st March 1882, or you can answer option number 4 also. The undertaking contained in a promissory note to pay a certain sum of money is conditional. Unconditional may be conditional or unconditional depending upon circumstances, none of the above. This is very basic. Promissory note, it has to be a conditional undertaking or a non-conditional undertaking. Come on. It has to be an unconditional undertaking, which is clearly mentioned under section 4. बहुत क्लियरली मेंशन है सेक्शन नंबर 4 के अंदर कि प्रोमिसरी नोट अनकंडीशनल होना चाहिए. उसमें कोई भी शर्त नहीं होती है. अंडर सेक्शन 4 के अंदर यही मेंशन है ऑफ नेगोशिएबल इंस्ट्रूमेंट एक्ट. अ बिल ऑफ एक्सचेंज कंटेन्स और एन अनकंडीशनल अंडरटेकिंग, अनकंडीशनल ऑर्डर, कंडीशनल ऑर्डर, अनकंडीशनल अंडरटेकिंग. बिल ऑफ एक्सचेंज में क्या होता है? अनकंडीशनल अंडरटेकिंग होती है, अनकंडीशनल ऑर्डर होता है, कंडीशनल ऑर्डर होता है, या अनकंडीशनल अंडरटेकिंग होती है. हिंदी में ही बात कर रही हूँ बोई मैं. लेट्स सी. बिल ऑफ एक्सचेंज में होता है अनकंडीशनल ऑर्डर, अनकंडीशनल अंडरटेकिंग नहीं होती है बिल ऑफ एक्सचेंज में. विच ऑफ द फॉलोइंग इज नॉट अ नेगोशिएबल इंस्ट्रूमेंट? नेगोशिएबल इंस्ट्रूमेंट, प्रोमिसरी नोट, करेंसी नोट, चेक और बिल ऑफ एक्सचेंज. नॉट अ नेगोशिएबल इंस्ट्रूमेंट. इसमें से क्या नेगोशिएबल इंस्ट्रूमेंट नहीं है? Let's wait for the let's see the answer, and let's wait for the timer. The correct answer is option number 2, which is a currency note is not a negotiable instrument. And that is very obvious that it is not a negotiable instrument. Okay, there was a network glitch. Okay, let's move ahead then. As per the Negotiable Instrument Act, the promissory note may also contain the promise of delivery of things along with money. Correct? Incorrect? Partly incorrect. Let's see the answer. And the answer is option number two. This is incorrect. The promissory note may not contain the promise of delivery of things along with money. It is not regarding the things, just the money. A check is a promissory note, bill of exchange, currency note, none of the above. Hi Muskan, welcome in the session. Let's see. A A check is a bill of exchange. It is mentioned in the definition only. Definition में ही ये mention है कि a check is a bill of exchange. Yes. Check bill of exchange नहीं है. A check is a bill of exchange और ये mention है section 6 में. The maker of a bill of exchange or check is called drawer, holder, debtor or payee. Maker of a bill of exchange. Please answer. Answer करो सब. The maker of a bill of exchange is option number one. Muskan सही थी. It is a drawer. Okay, let's. मेकर ऑफ बिल ऑफ एक्सचेंज, जो बिल ऑफ एक्सचेंज बनाता है उस वो ड्रॉवर होता है. आगे बढ़ते हैं दूसरे क्वेश्चन की तरफ. ओके, द नेक्स्ट क्वेश्चन इज where a bill or check is lost or destroyed, who is entitled at the time of such loss or destruction? Drawer, payee, holder, no one is entitled. जब एक बिल और चेक गुम जाता है, डिस्ट्रॉय हो जाता है, कौन इंटाइटल होता है उस लॉस या डिस्ट्रक्शन के लिए? ड्रॉवर, पेई, होल्डर या कोई भी इंटाइटल नहीं होता है. मुस्कान ने बोला है ऑप्शन नंबर थ्री. लेट्स सी. यस, इट इज ऑप्शन नंबर थ्री. जब एक बिल या चेक गुम जाता है, बिल ऑफ एक्सचेंज या चेक गुम जाता है, तो होल्डर उसके लिए एंटाइटल्ड होता है. Okay. The term holder in due course has been defined under which section of the NI Act? 8, 9, 14. The term has not been defined under Negotiable Instrument Act. Holder in due course किस section में defined है Negotiable Instrument Act के? Holder in due course. Yes, it is option number 3, which is section 8. Section 8 it is. If an instrument may be construed either as a promissory note or a bill of exchange, it is a valid instrument, a returnable instrument, an invalid instrument, an ambiguous instrument. Okay, it is 9. Let's see the answer. Yes, it is 9. 9, sorry, 8 defines holder and 9 defines holder in due course. Yes, 8 defines holder and 9 defines holder in due course. Yes, correct, correct. Shaktija is right. Sorry for the confusion. Holder और holder in due course में difference है. ओके, इसका आंसर दो. मुस्कान इज सेइंग 1, बोहेमिया कह रहे हैं 2. लेट्स सी द आंसर. द आंसर इज ऑप्शन नंबर. ओके, this is the question, right? If an instrument may be construed either as a promissory note or as a bill of exchange, it is a valid instrument, a returnable instrument, an invalid instrument, or an ambiguous instrument. It is an ambiguous instrument, guys. Section 7 defines कि जब दोनों होता है तो उसको हम ambiguous instrument कहते हैं. Who administers? Okay, so this is done. नेगोशिएबल इंस्ट्रूमेंट एक्ट हो गया है. लेट्स मूव अहेड. जो सबसे ज़्यादा वेटेज का सब्जेक्ट है विच इज़ कॉन्स्टिट्यूशन ऑफ इंडिया. इन तीनों सब्जेक्ट्स में से अभी उनका वेटेज कम हो गया है एमपी में. बट नाउ लेट्स मूव अहेड विद द इंडियन कॉन्स्टिट्यूशन. हु एडमिनिस्टर्स ओथ ऑफ द गवर्नर ऑफ अ स्टेट? प्रेसिडेंट ऑफ इंडिया. हाँ, मैं हिंदी में बोल रही हूँ. ओथ कौन एडमिनिस्टर करता है गवर्नर ऑफ अ स्टेट को? प्रेसिडेंट ऑफ इंडिया, चीफ जस्टिस ऑफ द स्टेट हाई कोर्ट, एडवोकेट जनरल ऑफ द स्टेट, नन ऑफ द अबव. Who administers oath to the governor of a state? यहाँ कंफ्यूज हो जाते हैं सब. प्रेसिडेंट को ओथ जो एडमिनिस्टर करते हैं वो हैं चीफ जस्टिस ऑफ द सुप्रीम कोर्ट. तो वाइस प्रेसिडेंट को जो ओथ एडमिनिस्टर करते हैं वो है प्रेसिडेंट. सुप्रीम कोर्ट के जजेस और हाई कोर्ट के जजेस को जो ओथ एडमिनिस्टर करते हैं वो है प्रेसिडेंट. लेकिन गवर्नर ऑफ द स्टेट को जो है ओथ एडमिनिस्टर करते हैं वो हैं चीफ जस्टिस ऑफ द स्टेट हाई कोर्ट. शक्तिजा इज राइट. ठीक है. A person whose fundamental rights are violated can move to the High Court under Section 20, Article 20, Article 226, Article 32, Article 22. जब किसी का फंडामेंटल राइट वायलेट हो जाता है तो वो हाई कोर्ट में किस आर्टिकल के अंडर मूव कर सकते हैं? Yes, it is Article 226 and Article 32 is for Supreme Court. हाँ, बोहेमिया ने भी सही बोला था. ठीक है. और 226 हाई कोर्ट का है, 32 सुप्रीम कोर्ट का है. जब आपके पास राइट है कि जब आपका फंडामेंटल राइट वायलेट होता है, आप डायरेक्टली मूव कर सकते हो हाई कोर्ट के पास. विच ऑफ द फॉलोइंग प्रोटेक्ट्स पर्सनल फ्रीडम? को वारंटो, मैंडमस, हेबियस कॉर्पस, सर्शरी. पर्सनल फ्रीडम कौन प्रोटेक्ट करता है? ओके, लेट्स सी द आंसर. इट इज हेबियस कॉर्पस. हेबियस कॉर्पस का मतलब है प्रोड्यूस द बॉडी. ये आपकी पर्सनल फ्रीडम प्रोटेक्ट करता है. प्रीएम्बल ऑफ द कॉन्स्टिट्यूशन डिक्लेयर्स इंडिया एज अ सोशलिस्ट डेमोक्रेटिक रिपब्लिक, अ सॉवरेन सोशलिस्ट सेक्युलर डेमोक्रेटिक रिपब्लिक, अ सॉवरेन डेमोक्रेटिक रिपब्लिक, नन ऑफ द अबव. प्रीएम्बल के वर्ड्स क्या हैं? करेक्ट. शक्तिजा एंड मुस्कान बोथ आर करेक्ट. आंसर है आंसर नंबर 2. प्रीएम्बल में क्लियरली लिखा हुआ है कि प्रीएम्बल ऑफ द कॉन्स्टिट्यूशन हैज टू बी अ सोवरेन सोशलिस्ट सेक्युलर डेमोक्रेटिक एंड रिपब्लिक. Okay, who among the following was the chairman of the constitution drafting committee? Dr. B R Ambedkar, Motilal Nehru, M K Gandhi, Sardar पटेल. कौन ड्राफ्टिंग कमिटी, कॉन्स्टिट्यूशनल ड्राफ्टिंग कमिटी के चेयरमैन रहे हैं? हम्म. ठीक है. करेक्ट आंसर है डॉक्टर बी आर अम्बेडकर. बी आर अम्बेडकर किस स्टेट से बिलोंग करते थे? प्लीज आंसर इन द कमेंट बॉक्स. Saffron color in the Indian national flag represents ascetic, sacrifice, brotherhood, secularism. Saffron color जो ऑरेंज कलर है अपने नेशनल फ्लैग में, इंडिया के फ्लैग में, वो किस चीज को रिप्रेजेंट करता है? व्हाइट किस चीज को रिप्रेजेंट करता है और ग्रीन और ब्लू? सब बताओ. करेक्ट. विच डिस्ट्रिक्ट शक्तिजा? बिहार अम्बेडकर. बोहेमिया कह रहे हैं 4, शकीजा कह रही है 1. दोनों गलत हैं. मुस्कान भी गलत है. इट इज सैक्रिफाइस. ब्रदरहुड इज वाइट. Brotherhood is white. Which of the writs can be issued by a high court to direct a public officer or the government not to enforce a law which is unconstitutional? Certiorari, prohibition, quo warranto, mandibus. लेट्स सी द आंसर. चलो आंसर की तरफ देखते हैं कि आंसर क्या है. The answer is option number 2. Yes, prohibition is the correct answer. Public officer की जब भी बात आती है तो prohibition comes to the in the picture. Co warranto is something else जो अभी हम देखेंगे. Which among the following writs literally means what is your authority? Certiorari, habeas corpus, co warranto or prohibition. किन रिट्स किन इनमें से किस रिट का मतलब है व्हाट इज योर अथॉरिटी? ओके. इट has the answer is, what is your authority? The answer is co-warranto. Yes, so Shaktija is right. Green का मतलब है prosperity and blue color का मतलब है 24 hours continuity. White का मतलब है brotherhood और uh, saffron color, that means the orange color means sacrifice. Okay. Orange, we cannot call it orange. It is called saffron only, but it resembles the orange color. Resembles the orange color मतलब हम उसको orange नहीं बोल सकते हैं, उसको saffron ही बोलते हैं. Saffron मतलब केसरी कलर, लेकिन वो क्योंकि orange जैसा लगता है, तो इसलिए उसको हम orange बोल मतलब regular language में we can call it orange. टेक्निकली उसको सैफरॉन ही बोलते हैं. विच आर्टिकल प्रोवाइड्स फॉर पर्सनल इम्यूनिटी टू द प्रेसिडेंट एंड गवर्नर फॉर ऑफिशियल एक्ट्स? कौन सा आर्टिकल पर्सनल इम्यूनिटी प्रिविलेजेस प्रेसिडेंट और गवर्नर को बोलते हैं देते हैं फॉर देयर ऑफिशियल एक्ट्स? 362, 363, 368, 361. मुस्कान के अकॉर्डिंग इट इज 361. Let's see the answer, and it is 361. Municipalities have become constitutional functionaries by insertion of which article? 243Y, 243Q, 243Z, none of these. कॉन्स्टिट्यूशनल किन से हुए हैं? कॉन्स्टिट्यूशनल स्टेटस म्यूनिसिपैलिटीज को किस आर्टिकल से मिला है, इसलिए आर्टिकल इंपॉर्टेंट है. लेट्स सी द आंसर. कोई नहीं पढ़ता है 243 वाले आर्टिकल. व्हाई नन ऑफ दीज? अच्छा, पिछला आंसर है शक्तिजा का 361. यस, आंसर इज ऑप्शन नंबर 2, 243Q. Preamble is the part of the constitution. ये किस केस में बोला गया था? This is very easy. केशव नंदा भारती versus state of Kerala, विशाखा versus state of Rajasthan, DK Basu versus Union of India, RS Nayak versus AR Antule. मुस्कान के अकॉर्डिंग इट इज ऑप्शन नंबर 1 और आंसर है ऑप्शन नंबर 1, केशव नंदा भारती versus Union of India. Yes. Preamble of the Constitution was amended and the words Sovereign Socialist Secular Democratic Republic were substituted for Sovereign Democratic Republic via 93rd Amendment with effect from 20th November 2006, 85th Amendment with effect from 17th June 1995, 42nd Amendment with effect from 3rd January 1977, 44th Amendment with effect from 20th June 1979. दोनों के according it is ऑप्शन नंबर 3 एंड इट इज ऑप्शन नंबर 3. प्रियम्बल एक ही बार अमेंड हुआ है. इट only has been amended once via 42nd amendment. Which schedule of the constitution mentions the union list, state list and concurrent list? 7th schedule, article 246. 8th schedule, article 245. Come on, tell me कि कितने कितने सब्जेक्ट्स हैं इन यूनियन लिस्ट, स्टेट लिस्ट एंड कॉन्करेंट लिस्ट? It is the 7th schedule. 7th schedule is the correct answer. Who is not a citizen by domicile? Those who are born in the territory of India, those whose either mother or father was born in the territory of India, those who have been ordinarily residing in the territory of India after commencement of the Constitution of India due to his work in India, who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding commencement of the Constitution of India. एंड द करेक्ट आंसर इज ऑप्शन नंबर 3. देयर वाज नो, यहाँ पे कोई इंटेंशन नहीं है रहने का. द पर्सन इज स्टेइंग, यहाँ पे इसलिए रह रहे हैं वो क्योंकि उनका काम है यहाँ, तो इसलिए ऑर्डिनरी रिजाइडिंग, इसलिए कोई वो ही इज नॉट अ सिटीजन बाय डोमिसाइल. ही कैन एक्वायर सिटीजनशिप दूसरे तरीकों से, उसको मिल सकती है, लेकिन वो डोमिसाइल के रूप पे सिटीजन नहीं है. 5 years वाला प्रोविजन है कॉन्स्टिट्यूशन में, मुस्कान एंड शक्तिजा. The president can obtain opinion of the Supreme Court in which of the following cases? Where he is advised by the cabinet ministers to refer the matter to the court for its opinion. Where is advised by the prime minister to refer the matter to the court of its opinion. Where the question of law or fact has arisen or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the court. None of the above. Yes, it is option number 3. आर्टिकल 143 ऑफ द इंडियन कॉन्स्टिट्यूशन में ये लिखा हुआ है कि जब मैटर पब्लिक इंपॉर्टेंस का होगा और व्हेन द क्वेश्चन इज ऑफ ईदर लॉ और फैक्ट. Under Article 227 of the Constitution, who has superintendence over all the courts and tribunals located in the territory to which it exercises jurisdiction? State government, central government, Supreme Court, High Court. 227, यहाँ पे just apply your mind कि ये किस पे apply होता है. 227 chapter कौन सा है? You'll get the answer. Okay, let's see the answer, and it is the High Court. Yes. uh, uh, ये बताओ कि the order of the Supreme Court is binding on all the courts is mentioned under which article of the Constitution of India? Binding on all courts. Which of the following is not a safeguard available to a member of civil service of union or of a state? Not a safeguard. That he shall not be dismissed or removed by, yes, it is 141. Okay, so remember that concurrent list has the least number of subjects. Which of the following is not a safeguard available to a member of civil service of union or of a state? That he shall not be dismissed or removed by any authority subordinate to that by which he was appointed. That he should be informed of the charges against him. That he was given a reasonable opportunity of being heard in respect of those charges. That he should be given an opportunity to submit a declaration that he will not commit in future such misconduct for which he is charged with. Not a safeguard. It is option number 4, which is mentioned under Article 311. बाकी सब तो obviously rules of natural justice हैं, option 2 and 3. Or option number 1 is applicable on all the public servants. Which is the latest case wherein constitutional bench of the Supreme Court has reviewed the amending powers of the Parliament under Article 368 of the Constitution? Golaknath versus State of Punjab, Indira Gandhi Nehru versus Raj Narayan, मिनर्वा मिल्स वर्सेस यूनियन ऑफ इंडिया, केशव नंदा वर्सेस स्टेट ऑफ केरला. आपसे एक्सपेक्टेड है कि आपको इनके ईयर्स याद होंगे बिकॉज दे आर सच लैंडमार्क केसेस. थोड़ा सा दिमाग लगाना पड़ेगा. एंड द क्रोनोलॉजी ऑफ केसेस सेज दैट मिनर्वा मिल्स इज द लेटेस्ट वन. इंदिरा गांधी नेहरू ऑब्वियसली 1975 में आया था बिकॉज उनका उनका प्राइम मिनिस्टर का जो टेन्योर था वो 1975 में था. केशव नंदा भारती इज 1973. गोलकनाथ इज द oldest one. Which constitutional right is a not fundamental right? Is not a fundamental right? Right to equality, right to freedom, right to life, right to property. Come on, this is very easy. This is very basic. Let's see. The correct answer is right to property. Right to property was removed by which amendment? And uh, the option number 4 is the correct answer, and it is moved to. And right to property is what kind of a right now? Is it a constitutional right or a legal right? यहाँ पे confuse होते हैं लोग, and it is under Article 300A. The word socialist and secular were inserted in the preamble of the Indian Constitution by 40, sorry, 15th Amendment of the Constitution, 49th Amendment of the Constitution, 42nd Amendment of the Constitution, 44th Amendment of the Constitution. I was answering it myself. Yes, it is a legal right now, and it is through the First Amendment Act. Right to property remove कब हुआ था? Not First Amendment. Yes, the answer is option number 3. Please check again, Shaktija. Right to property, fundamental right की list से उठा के 300A में किस amendment के through करा गया? Which within the meaning of Article 3 under the Indian Constitution, the Parliament by law may or can form new states, alter the areas of states, alter boundaries or the names of the state or existing states, All of the above. Yes, it is 44th Amendment. जो भी ऐसे याद रखा करो, जो भी अच्छी चीज़ें हुई हैं, वो 44th अमेंडमेंट उससे हुई हैं। जो भी you can say restriction of powers of judiciary or restriction the enlargement of powers of parliament, ये कहीं भी ये हुआ है वो 42nd अमेंडमेंट से हुआ है। You can डिसाइड योरसेल्फ कि ये अच्छी बात थी या गंदी बात थी, बट 44th से सब कुछ बहुत अच्छा हुआ है। Yes. First Amendment is somewhere else. I'm not remembering it, but First Amendment is somewhere else. Okay. It is option number four. Yes, they can do all with a simple majority. Article 5 of the Constitution of India talks about a person who has his domicile in the territory of India at the commencement of the Constitution shall be a citizen of India. The expression every person in the Constitution of India includes a prisoner, member of the armed forces, person born in the territory of India, all, all of the above. Yes, it is option number four. A prisoner है तो citizen तो होगा ही, and members of armed forces तो obviously they are our army, वो तो citizens हैं ही. Why option number three? बेचारे prisoners हमारे citizenship थोड़ी जब जिसका domicile है, so they'll be obviously included. Okay. Which of the following is included in the concept of state under Article 12 of the Constitution of India? Railway Board, Judiciary when exercising administrative functions, Government University, all of the above. Let's see the answer under Article 12. बहुत सारे case laws हैं. You have to remember the names of the case laws also. And it is A.R. Antule versus R.S. Nayak, which is the case which held that judiciary while exercising the administrative functions is also a state. बाकी तो obviously railway तो है ही state and government university. Article 15 of the Constitution of India does not permit the state to make special provisions for one of the following. Which one is that? Socially and educationally backward classes, a class of specific region, only scheduled caste and scheduled tribe, none of the above. Yes, it is option number two. It is very basic. In which of the following case says the Supreme Court has elaborately issued the guidelines on child labor under Article 23 of the Constitution of India? MC Mehta versus State of Tamil Nadu, Bandhuwa Mukti Morcha versus Union of India, Madan Gopal versus State of Odisha, both A and B. And it is the last question for today. Okay, please name the case here, and the answer is option number four. Both one and two it is. Bandhuwa Mukta Morcha is one of the landmark cases on child labor. Come on. मतलब आई वुड हैव बीन कंफ्यूज्ड इन बंधुआ मुक्ति मोर्चा, मैं सिर्फ ऑप्शन नंबर टू करके आती अगर मैंने पढ़ा नहीं होता, बट इट इज बोथ. चाइल्ड लेबर इज ऑल्सो एमसी मेहता एंड इट इज बंधुआ मुक्ति मोर्चा ऑल्सो, बोथ एन बी. ठीक है. Please name the case, Shaktija, because what I know is and what I have read recently is that judiciary administrating the exercising the administrative functions is a judiciary, is a state, not the legal functions. Okay, please let me know the case law on WhatsApp. Yeah, we can discuss it after the session. So this was all, guys. I know you have a yes, please do it, and then I'll check it and let you know because I know you have your paper. अगर यही question आ गया तो गलत नहीं करके आना है. So all the best for MP Shaktija. Muskan, I know you are not giving the paper, but your preparation is on point. So all the best, and let me know in case you have any other problems, both of you. And how was the session? Please comment your inputs. That will encourage me to take further sessions also. You're welcome. You're welcome. JJ, you require a good hold, Shaktija. Like 3 marks हैं लेकिन थोड़ा बेयर एक्ट पढ़ लो उसका. At least the committees, not everything, but थोड़ा बहुत. Okay, चलो ठीक है. I'm signing off. Thanks for the patience. Good night.